Yes, I salute you all. Thanks for listening and thanks for watching. So basically today we are under the law of contract, that is contract law 2. And today we are going to look at mistake as a vitiating factor of a contract basically. We defined a contract using section 1 and section 9 of the Contracts Act basically. And what you have to bear in mind in this essence is that any question towards contract law, you must first define what a contract means basically. And we are going to look at mistake as a vitiating factor. It is provided under section 12 of the Contracts Act, which is mistake, which as well as means as a vitiating is a vitiating factor. So in this essence, or what we look at, it makes the contract voidable. Mistake, not that in mind, that mistake makes a contract voidable. You get? So in this essence, or what you are looking at mistake as a vitiating factor. And the mistake, it has many categories. I cannot define mistake as in a mistake, but you use the English meaning that a mistake is that you do something mistakenly, either in any category, but it is not right. You do something that is not right, or you presume something that is not right. You get that is provided under section 12 of the Contracts Act. So we are going to see the different types of mistake. First of all, we have common mistake, unilateral mistake, and mutual mistake. We are going to first see by common mistake. Common mistake in contracts law, basically it means that the parties make the same error. You get? It is common. Both parties are what? Both parties are in a mistake. Both of them, they're in a mistake. And in this essence, none of the parties knows the truth. That's what I can say. That the other party is naive about the right thing. Even this party is naive about what? The right thing. That is common mistake. And under common mistake, we have like three. They are like elements of common mistake. They are like three. One of it is a res extincta. Res extincta, this is where the subject matter is non-existent. That the subject matter doesn't exist at all. You get? That is res extincta. We have the case of Courtier versus Haste. Courtier is Courtier. Hestia is Hastei versus Hestia. This was in the purchase of corn, but however, the one that was delivering or the one that was shipping sold the corn on the way because it was getting spoiled. So realize that here this one was selling things that were non-existent, and this one was also selling things that are non-existent, buying things that are non-existent. That calls that there was no subject matter, and it makes the contract voidable. And the good example that I can use is that, take for instance, I have a motor vehicle and I promise to sell it to you. So we meet in town to make a business. We meet at Cafe Javas in Kampala and we drink tea, as I'm telling you, as we are making business. Unfortunately, I left the car home, but they've stolen it. Me selling it to you, I don't know whether it is still there or it is stolen, and the one buying is naive about the same. So it becomes a mistake, a common mistake under the element of res extincta, basically. Moving forward, another category, you have resua under common mistake as an element. Resua basically it means you purchase something that already belongs to you. You get? That is resua. You are purchasing something, but it is already belonging to you. The thing is like this: they've stolen your phone in town or in a show. You have went in a concert. They've stolen your phone there. In the morning, as you're moving in town, realize that you want a new phone. You go to a phone shop. Realize that they are selling to you. They've sold to you your very phone, and after you realize it that the phone that I'm buying already belongs to me. You get? So that gives that element that it is a common what? A common mistake. You get? You have the case of copper versus fibs. Under that case, provides that element that where a person purchased something that already belongs to him, that person is not entitled. It actually makes the contract can be declared what? Void in that regards, or in that what? That manner. You get? Another thing what we can look at, we have what they call mistake as to the quality. Mistake as to the quality. Mistake as to the quality, basically, the case that I can give. The case that I can give is that, or the scenario that I can give is that you have went to buy maize flour, number one, but realize that you instead take number two, but you realize the mistake after. So that is a mistake as to the quality. Even the purchaser may give you, actually it is going to the shop, you want maize flour number one, but you don't know how it looks like. Unknowingly, the attendant in the shop gives you another number. So you will go home and realize that it is not the one. So that is mistake as to identity, basically. We have the case of Saul versus Butcher. That is a good case on identity. This one, there was an element of non-disclosure. This one thought the payment was only this. Unfortunately, there were other payments. We have the case of Smith versus Hughes. Smith versus Hughes is also a good case. You get however much it is. That case it is where in a element of silence does not amount to a misrepresentation. Smith versus Hughes. It also deals there in mistake to the quality. He wanted, under the case of Smith versus Hughes, he wanted old oats, but he was given new oats for his horses. So that's it. That is all about common mistake. Then we have what they call unilateral mistake. Unilateral, what I can say about unilateral, this is where one part is mistaken. Only one part is the one that is mistaken, but the rest of the parties are aware, and they are really informed that this part is in a mistake. But one part is in the mistake, the other one is aware of the mistake that is being performed by the other party. You get? So in this essence, or in this regards, realize that that amounts to a common, it amounts to a unilateral mistake. Unilateral mistake, it also has like two categories. We have mistake to the terms of the contract, and also mistake as to identity. Mistake as to identity, mistake as to the terms of the contract. Remember, unilateral, this is where one party is mistaken and the other party is aware of the mistake, basically. So in this essence, let me start with mistake as to the terms of the contract. Realize that many of us interpret certain terms and clauses in a different way. Realize that they've told us that the document they're signing provides for this and this, but for you, the document is talking something else. You get? Take for instance, mistake as to the terms of the contract. Take for instance, you are making a contract with someone about maybe you are a tenant, because most of us are tenants out there. Take for instance, you have a tenant, and the tenant's agreement, there are a lot of clauses. There is a clause that says that, you know what, we don't accept married people in our houses. Impliedly, they are also refusing you to bring children. That's the emphasis. Where some landlords don't allow married people, they don't want children on their houses. But it is that the clause is that we don't allow married people in our houses. So at the end of the day, if you bring children, the landlord will tell you, no, I told you I don't want married people. Then you'll be like, but you said married people. I don't have a wife, but these are my children. So basically, the landlord will say that me telling you married people, I mean that I don't want a family. So that is a mistake to the terms of the contract. You have mistaken some terms to mean something else. You have been so precise in the interpretation. Basically, we have the case of, to the terms of the contract, Hartog versus Collin and Shields. Hartog versus Collins and what? And Shield. That case provides that element that where the parties are mistaken with the terms of the contract, that contract is made under mistake, a natural mistake, and the court can declare it as what? As a void, because it is voidable at the face of it. Then we have mistake as to the terms, mistake as to the identity. We miss, actually, mistake to identity is that you mistake someone for something else. You have two categories of mistake to identity. We have mistake in terms of, in identity in inter absentees and inter presents. Inter absentees whereby you deal someone, they are dealing someone that is not around, basically. That is not around. For example, the case of Candy versus Lindsay. It was a delivery whereby it was delivered to wrong address. It was delivered, Candy versus Lindsay. It was delivered, the delivery, it was delivered to wrong address, basically. We also have the case of Kings Norton. Kings Norton versus Kings Norton Metal Company Limited versus Endrin. EDRIDGE. Enridge Merete Company Limited. Under this case, the innocent party believed that he was dealing with a reputable firm, law firm. However, it was not. You get. So that is to do with the mistake on terms of inter absentees. Then when you come to the mistake as in terms of interpresence is that you are dealing someone knowing that this is the person that I want. Unfortunately, it is not the person that you want. You have gone in town to meet maybe a famous lawyer, but you have just found a law student that is giving you advice. And you, take for instance, I may go to town and they say that I'm Elias Lukwago. And I meet a client. A client is in a presumption that I'm Elias Lukwago. You get? So there is that mistake whereby the other party knows that he's not Elias Lukwago, but me, in my mind, I know he's Elias Lukwago that I'm dealing with. That is mistake on grounds of interpresence. One party is mistaken, but the other one knows that the other party is in the mistake. Basically, not that in mind. Under interpresence, you have the case of Lake versus Simmons. That case provides that element very well, basically, as to the mistake on terms of interpresence. Then, after unilateral mistake, we can see the case, we can see mutual mistake. Mutual mistake, basically, I can say that this is where parties fail to understand each other. They fail to understand each other. That is mutual. For example, you are backbencher in class. The teacher said, go. For you at the back, you are hearing went. So you fail to understand each other. This one on a target David, this one has understood his things, and you also at the back, you have understood your own things. In this regards, what we are presuming that the parties have failed to understand each other. For example, you may go to, you have also been victims. You go to a shop, you want something, but the attendant is trying to figure out what you are trying, what you want. He brings like 4 kinds. You say no, 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 which means that you are failing to understand each other, basically. So in this essence, it is like, it is a cross purpose. You get? It is a cross purpose. We have the case of wood versus scarf. Scarf. Wood versus scarf. Scarf is SCAR, scarf. SCARTH under that, whereby the parties, under that case, the court held that the parties had failed to understand each other in that regards. You get? Because that of a mutual mistake. You get? So then we also have documents that are signed by mistake. The general rule is, under documents signed by mistake, every person is bound by his or her signature. That's the general rule. That every party is bound by his or her signature. whether you have been forced or what and what, you are bound by your what? By your signature. You get where actually there is the case of Lestrange versus Jacob. Who actually will saw that case under the exclusion clauses, basically by signature. Lestrange versus Jacob, whereby they held that once you apex your signature on the document, you are bound by what is on the document. You have consented. You get. But however, you have what they call the non-extim factum. Non-extim factum, it basically means that it is not my deed. That is the essence. You're trying to mean that it is not my deed. I signed a document, but I signed it. It wasn't my deed. It may be maybe you are illiterate. You may be maybe you are told something that is different from what it is in the document. You are maybe misrepresented in any way. You are trying to say that it is not my what? My deed, non-extreme factor. You get, for example, you have the case of Saunders, that famous case there, Saunders versus Angalia Building Society. This was an old woman that was induced to dispose of his property in a will, claiming that he wanted for the benefit of his cousin, actually it was, is it the nephew, something, nephew or cousin. So as a result, they lied to him that the document of this disposal portrayed what her aspirations. But however, it was contrary. What was in the document was contrary to what he was told. So at the end, court held that he could claim a non-extreme factum, saying that it was not my deed, because me I wanted something else, but what I signed in the document was something else. Because when I was signing, I was also told something else. So that is the doctrine of non-extreme factum. It acts in where someone is illiterate person. You are illiterate, court will presume that you need a clear interpretation for you to understand what is the document. But even if you are an illiterate and you may be, it is your lawyer that signed on behalf of you, then you can't claim this defense. Reason being that you had the duty to ask details from your lawyer. You get. So that is the thing that I can tell you, that literate, even you may be educated, you may be an illiterate, you know very well, but once you are signing a document and the person tells you contrary or tells you what is the document and you say, you know what, let me, according to what he has told me, it is a good one, and you sign basing on his or her words. But after signing, you realize that what you are told it is far different. Then you can also claim non-extreme what? Factum. You get? So basically that is mistake as a topic, as a vitiating factor, or a vitiating factor in contract law. But other than that, thank you for listening and thank you for watching. Stay blessed, subscribe to the channel, like the videos, and make comments so that we can elaborate more. Thank you and good luck.